name is Deborah Gonzalez, and I'm your instructor for social media and the law. This session is going to be about social media and privacy, looking at the ethical and legal concerns of privacy, not just for us as attorneys, but also for our clients as we advise them. So very simply, I want to go over what social media is, just so that we have that basic definition. I also want to go over what I mean when I talk about privacy. I want to look at the violations of just one tweet, and then we're going to look at the American Bar Association model rules as it relates to some of the ethical issues with attorneys and privacy and what's going on social media. Okay? So let's begin. First thing I want to start off with, as always, is what are we talking about when we talk about social media? We're looking at it as a method of communication, as tools for communicating, but also understanding for some of our clients is the way that they interpret their world. It's the way that they interact in business, as well as the way that they interact with their family and their friends and their colleagues. Okay? One of the things that you have in your handout, and I'll tell you to Google, if you go to YouTube and put in "what if you asked," what Facebook asked, okay, and you're going to come up and you're going to see this little YouTube video right here. It's a great video because what it is two young gentlemen, and they walk around and they ask people the same questions that Facebook asks you when you're going to start a Facebook account. And then you look at the reactions of individuals when they're asked about, you know, where do you live? What are you doing at this moment? Will you agree to tell 10 of your friends? It's a very humorous look at, you know, we give so much information to Facebook. Why is it that we feel that we can, and yet we're so concerned about privacy and other aspects? So I want to make sure that you go and view that YouTube video. It's just a great insight as to what's going on when we talk about this. So if I asked you, do you know what privacy is, right? And, you know, it's interesting because what privacy is versus what is the ability to keep something private can be different. But when we're looking at privacy in the online world, what we're looking at is a person's right to control access to his or her personal information. Okay. Now, some people, when they first think of privacy, they think about the right to be left alone, right? The right to be able to go off in a corner and do what you want to do and nobody bother you, and you do it in the privacy of your home. But what we're talking about is really about access to the information that we put out there. So when we're talking about privacy settings on some of these social media networks, what we're actually talking about is who has access to my personal information on that platform, okay? Now, usually what happens is people don't sue for a right to privacy, they sue for an invasion of privacy, meaning that there's been a violation, that somebody has intruded into the life of somebody else, that they had no reason, and most importantly, that they did not have permission or consent from that person in order to go in and get that information, okay? And you know, one of the problems is not just the access to that information, is that how is that information used? What do they do with the information once they receive it? And that becomes a very big issue, and you hear about that more and more in terms of marketing. When people are using sort of some marketing campaigns like a sweepstakes or a contest, or even with the Facebook, when a company will set up a fan page and say, like us, okay, and sometimes once you like them, you're also opening up what's called a social graph, which is all the data and personal data that you have about yourself on that account, and they now have access to that, okay? Privacy also, I want you to understand that it's not only about that personal data, but it also includes workplace monitoring. And so if we're on the computer network at the workplace, whether that can be monitored by your employer, and as we know, there is no expectation of privacy for most of the time with what's happening in your office at your place of employment, okay? The desk is not yours, the computer is not yours if it's been provided for by the company, and so they have a right to check it and inspect it, and check and inspect the drawers of your desk, because there is not an expectation of privacy to a certain extent. Now, that doesn't mean that some workplaces might not be a little bit different. They might give everybody a key to keep their desk locked. Then there's sort of this issue that there is an expectation of privacy because they gave me a key so that I can keep people out, okay, or outside of those drawers. So you have to be very careful. This is another area that you want to look at. Maybe your company has a policy, your law firm may have a policy about privacy in the workspace, so you want to take a look at that. And on your handout, there's actually a link for you to look at some of that other information related to those issues, okay? Now, I have said this before, if you put it out on social media, you should consider that it's public, that it is not private, even if you do have privacy settings. You know, electronic communication is public, it's permanent, it's powerful, and it's out there. In the first session, I had sort of geared you towards a YouTube video that had a very important phrase that talked about, you know, what used to happen in Vegas stayed in Vegas. Well, now what happens in Vegas ends up on Twitter and Facebook and LinkedIn. And the big issue is that it's there because we put it there. Okay, so we have to keep that in mind, that it's not private because we make it public. We post it ourselves, about ourselves. Okay. Well, as I said, if the issue of privacy is about controlling the access to our information, well, what information is actually getting collected? What are people looking for when they get this information? And, you know, the broadest statement that we can say is they will collect any information that we give them. And it's really amazing how much information they can collect about us that's out there in public. They look at maybe not specifically identifying factors such as name and user ID, but they look at our browsing behavior. In other words, you know, what websites do we usually go to? What do we usually buy when we get to that website? Are we just looking how long may we stay there? They look at user preferences, they look at user credentials, and then they look at things like user location. Where are we? Now, there are specific social media tools such as Foursquare that uses the GPS system that's in our smartphone to identify the location of where we're at, and we're actually telling people where we're at, right? But if we're concerned about privacy and safety, one good tip that I can give you is that if you're going to use Foursquare, because people like it, it sort of has some game mechanics built in. If you get certain points, you can become mayor and get a discount sometimes at some of the places that you frequent. Check in when you're leaving. Don't necessarily check in when you get there. And that's just to keep privacy and safety there for you, okay? How is the information collected? Well, it could be through a survey, it could be through a registration for a particular, you know, RSS feed, or let's say a website offers you a free ebook or a free white paper about information, and they ask for your email and they ask for your company name. They're collecting that data, and it's just through that registration there. You've probably heard of cookies before, which is sort of these files that just keep track of all your keystrokes that you've done, and also through some of the mobile apps, like I mentioned, Foursquare. So you just want to keep that in mind. You know, one of the interesting things about Facebook is not only the type of information that they collect about you, but also all the information that they're collecting of all the friends that you have on Facebook. And that's what happens with a lot of these social networks. It's not just about getting the information about you, but also about your friends. So on Facebook, for example, they'll get things like your name, your gender, your age, and you know, they might not ask specifically for your age, but they ask for your birthday, and it's a very easy calculation from your birthday to then get your age, your birthplace or hometown, where you're from, your place of work, schools that you've attended, interest and hobbies, photographs, and from the photographs there's a whole bunch of other information that can be collected, like for example, do you live in a house or do you live in an apartment complex? Are you in a city or are you out in rural? Do you have pets? what kind of car you drive, because you might have a picture with one of your cars, what kind of pets you may have. I mean, there's lots of information that can be gotten just from one photograph. Also, who your friends are, you know, and where those friends are located, the activities that you take, that you may participate in. So for example, you went up hiking on a mountain and you've got a picture, you know, of you hiking on the mountain. Well, now people know that you're an outdoors type of person, that you like nature, that you could be found hiking on certain days. Okay, so lots of information from just putting up that one piece. And then also political bias may come out. Maybe you know, you post something about supporting a particular candidate. Now, this is just basic information, those basic questions that Facebook asks, and so they're finding that out not just about you, but also about your friends, and then they can make the connections between that. Okay, so it's important to keep that in mind. There's just a little snippet of the information that they get on you. Now, how is the information used, right? Because that's the other question. Once they have it, what are they going to do with it? And you hear about this a lot in terms of marketing. What do the marketers want to do? And sometimes they'll say, well, this is for customer service, right? If we know more about our customers, then we're going to be able to give them a better customer service experience because we know what it is that they like, and then we can, you know, sort of adapt the products or adapt the services for that particular client, okay? Maybe it has to deal with getting evidence about an individual or an opposing party for a trial or case. Maybe it's about employment issues, okay? Whether it's to hire somebody, whether it's to terminate an individual, whether it's to promote somebody or even evaluate their performance, there might be some HR concerns in there. Maybe it's being used for training of the individual for the particular position that they have, or maybe a future position that they might be being able to be considered of. So you want to keep that in mind. Now, a lot of these issues on privacy came out because people started looking at what are called terms of use or terms of service for these social media platforms. And those are those, you know, long legal disclaimers and stuff that you sort of have to click on I agree in order to get your account. Now, we know that most of the time what happens, people don't read them. They just click on the I accept so that they can then get the account. But we are bound by those terms of use. And lots of the terms of use will talk about how these social media platforms can actually use the information that we post on their sites to help them with marketing or to help them with other particular ways of them promoting themselves. So you want to be very careful about that. So, you know, when you look at things like Facebook and look at the privacy preferences, now, one of the things to keep in mind of Facebook is the idea that they constantly change their policy, they constantly change their rules. Developers are always saying how Facebook is constantly changing some of the codes and some of the things you can and cannot do. So just because you set your privacy preferences in the beginning, when you first set your account, you should check them at least once a month, or at the latest, you know, once every other month, just to check and make sure that they're still at the settings that you need. Okay, now I'm using Facebook as an example through the current policy that they had when I pulled this off about how they say that they can and will use user data. So I want to go through this list with you. They say that they will use the data to manage the service. They will use it to contact you. So that email that you put in there, that's the way they're going to contact you. To serve personalized advertising to you. Okay, and this is how they sell it to those third-party marketers. So the marketers know that they're going to get it to a very targeted audience. So keep that in mind. They say that it's to serve social ads. Now, what's the difference between a social ad and a regular ad? What do they mean by social ad? Well, you know, it's not a good, it's not a service. It may have to be something that deals as a service for a social group, or the way that, you know, a social team would then work. So that's what they mean by social ads. A lot of experiential type of services there. To supplement your profile. Now that's kind of scary, to supplement your profile. Does that mean that they can add things to your wall and your profile based on stuff that you've said? Okay, so be on the lookout for that. To help your friends find you. It's one of the reasons why they're putting this up. And you know, you might see sometimes on LinkedIn, we'll give you this list. Oh, these are people you might know that you might want to connect with. And Facebook will do that as well. Well, these are your friends who found other people. Maybe you want to find your friends. And I can remember listening to somebody on a dialogue who says, you know, sometimes you don't want those friends from high school to find you again. There was a reason why you sort of lost touch and you wanted to forget them in a way. We should be allowed to forget people if that's what we want to do. And sometimes this technology just doesn't allow that. It lets people to find us very quickly. Okay. It helps also memorializing accounts. Now that's what happens when somebody dies and the family wants to then create a memorial with the Facebook account, and Facebook uses the data that we've provided in order to do that. Okay. But that's not all. Wait, they do some more. They use it to help you make a payment. Now you're going to tell me, well, wait a minute, Facebook is free. I didn't have to pay for my account. But if you use, you know, some of the other services like Zynga Games, who are the makers of Farmville, and they make their money through microtransactions. The idea that, you know, if you want some crops on your farm, you're going to pay a certain amount of money. Well, that exchange of money, right? That's what Facebook is talking about, that they can then use your data in order to make that financial transaction occur, okay? Not only to help you find friends, but then to help friends find you is another way to do that. To give search engines access to some of your information. So now it's just not, you know, the information that you're keeping on just Facebook, but now search engines like Google and Yahoo will be able to find you and information that you post on these social media platforms as well, to provide you with better services, to offer joint services with other people. Okay, so that's a very long list of all this stuff that they're going to do with your data. Something that I thought was very important, because we're in the legal community, is also the fact that they say that Facebook will use user data to respond to legal requests and prevent harm. You know, there's this unbelievable statistic, right? Facebook now has over 800 active user accounts. How many accounts a day that they actually deactivate because they feel that there is some kind of harmful activity that's happening on that, or there's some kind of hate speech or discrimination or some kind of criminal activity, okay? So Facebook does have a division that sort of is looking at these things and trying to get them off the network as quickly as it can, and to respond to subpoenas, right? Or to respond to takedown notices from, for example, the Digital Millennium Copyright Act, the DMCA, where somebody may claim, you know, there is infringing material on that account. I need you to take it down. So Facebook is also using the data to be able to adhere to some of those legal responsibilities that they have, okay? There is a site, a link that's in your handout so that you can go specifically to the private policy. And again, it might have changed from the time that I prepared this to the time that you actually go online and see it. But those are the basic parameters for that, okay? So that's Facebook. Let's move on now to LinkedIn. And most of the time for LinkedIn, people want it to be public. They want people to find their LinkedIn profiles so that they can then consider them for either a consulting job or a regular job or a referral, or to check out their expertise. People really do want to be found on LinkedIn for very particular areas. That's why there's, in the LinkedIn profile, you're asked for specialty areas, or you're asked for interest or keywords so that they can keep that in mind, okay? But there is one thing that I want you to be very aware of. LinkedIn has this, what's called an option for social media advertising, and you actually have to opt out of it. You have to uncheck this in your LinkedIn profile. If not, they will use your profile for social media advertising. So what you want to do is you want to go to your settings page on your LinkedIn. You want to click on account, and then on the column under account that says manage social advertising. Okay, so settings account, manage social advertising, and then check off, deselect the box that says LinkedIn may use my name, photo, and social advertising. Uncheck that so that you opt out, so that you say it's not okay for them to use it, okay? And that's just another way for you to keep some of your information private in terms of not being used for a commercial reason that you're not going to get any benefit from. Okay, so now I want to give you an example of a very particular social media networking platform and some violations of privacy laws that it could happen. And what we're going to use one tweet. And it's estimated that one wrong tweet can violate over 17 federal privacy laws. Okay, and these include health laws, these include financial laws, the online privacy laws, communication laws, education laws, and others. But not only can one single tweet violate 17 federal laws, but they can also violate state laws. And in California alone has 88 privacy laws that can be violated by a tweet. Okay, so it's something that you need to keep in mind. You know, and not only are the privacy laws, but very closely attached. And most people will say, well, California, yeah, because they have all these celebrities. And that's very important to keep in mind, especially if you practice entertainment law, because the privacy is very closely connected with publicity laws. Now, publicity laws are state laws, right? It's the idea that you have a right to earn money, to earn financial compensation for your likeness, for you, your personality, the person that you are. Those are the publicity laws, okay? And that also works hand in hand, not only with the privacy and the publicity laws, but then that works hand in hand with the defamation laws, libel and slander. And online, it's considered libel, the idea of, you know, saying a false statement, knowingly saying that a false statement about another person that causes them harm, okay? And so things that we look at now is the idea of a public versus a private persona. And sometimes you can lose the idea of being a private persona if you're involved in a story that may be very newsworthy, okay? The idea of famous versus notorious, right? Why are people famous? Does that make them a public persona? And then something that's come up, especially in the entertainment arena, is this idea of reality TV stars, because they're famous for being famous. They're not famous for being a movie star. They're not famous for being a great actor. They're not famous for being a great singer or a great performer. They're just famous for being on a reality TV show. And so does that make them public or private? Do they have privacy rights that somebody else might not have because they're only famous for being famous? So it's still something that's out there. So let's take a look at some of the federal laws that relate with privacy and this wrong tweet. And we start with health privacy laws. And there are two of them that I want to bring up. The first one was actually passed in 1974, and it's the National Research Act. And this is not just research done by universities, but also research done by medical doctors in hospital and those kind of things. So you have to be careful that if you tweet something that you're not tweeting about that particular study or something related to the study, you can be in trouble with that act. But there's another one in 1998, probably the one that most people think about when they think about health privacy, is the HIPAA, the Health Insurance Portability and Accountability Act, HIPAA. Really focused on making sure that patient data does not get into the wrong hands and that there's not a breach of confidentiality when it comes to this. So, you know, be very careful about what's being tweeted by a patient, but also if you have a client who's a doctor, making sure that your client, the doctor, as well as the rest of his staff, understand if they are tweeting or if they are on Facebook, how these laws can apply to what they're talking about when they talk about their patients, okay? So very, very important. Those are the health ones. Then we have some financial ones. And you know, the financial industry is one that is very, very heavily regulated as to what financial representatives can actually talk about, not just in social media, but even in email or even when they're advertising. So the kind of disclosures that are required by the SEC, the Securities Exchange Commission, when they do this. So some of the laws that we need to look at there is the 1970 bank secrecy law. Make sure that, you know, bank tellers, even bank tellers are not tweeting the wrong thing. So a big part of this when it comes to your clients is if they are in these industries, that they make sure that they educate and train their employees as to what these responsibilities are and how important it is that they're careful, that they are in compliance with these regulations and with these laws. Another one is just the 1998 that created the Federal Trade Commission and the SEC. One of the things that you can do is if your clients are really in the financial industry, go to the SEC page, go to the FTC page, and you're going to see that they have guidelines. Every once in a while they'll set up and they'll send out guidelines as to how social media needs to be used, what disclaimers must be there, what disclosures. So if you're in that industry, if those are where your clients are, you need to keep up to date on what these regulations are for your clients so that they're not in violation with this. The 1999 Graham-Lee-Bailey Act, the GLB Act, you want to make sure about that. The Sarbanes-Oxley Act that came out in 2000, and the 2003 Fair and Accurate Credit Transactions Act. You know, we've had a couple of articles that you've probably seen out there that talk about, you know, debt collectors trying to track down people on Facebook and sending them messages. And, you know, the problem is that that message, they put that message on the wall and it goes out to all their friends. And so it really does go against this act. Now, one of the things that I hope you're keeping track of is these laws, right? They're from 1970, 1980, 2000, 2003. These are all laws that were put in place before social media really hit. They still apply to the data because social media is a method of communication, okay? So the laws still apply and you need to be aware of them for your clients. And then we have just straight Online Privacy Act, 1986, the Electronic Communications Privacy Act, and the 1988 Stored Communications Act. Now this is going to be one that we need to really look at as our clients start using a technology called cloud technology for storing their data. This Stored Communications Act may actually help keep the companies that are offering cloud storage a safe haven from liability for data loss. So this is something that you need to take a look at with your clients and read those contracts carefully if they are going and putting their stuff out on the cloud, okay? There are then some communication privacy laws. So we start with 1975, the Foreign Intelligence Surveillance Act, 1984, the Cable Communications Foley Act, 1980, the Electronic Communications Privacy Act, in 1994, the Digital Telephony Act. Now this last one, the Digital Telephony Act, just think for a minute, and you might not know this, whether in your law firm you have voice over IP for your telephone systems, okay? Or even your clients may have that. In other words, they're not going through a landline, but they're actually going through your internet connection. That 1994 Act, that's how many years ago? Think about it, that's over 17 years ago. That's going to affect what's happening through your telephone right now for voice over IP. So keep that in mind. Okay. Then we look at things like the education privacy laws. So some of you might have students in college. Your children may be old enough to be in college, but also you may have a client who's a higher education university or a college or one of these for-profit companies. The 1974 Family Educational Rights and Privacy Act, FERPA, makes it illegal to disclose any kind of student information. And so we have to be very careful again to train everybody in that university or college as to what they can and cannot tweet or post or say about a certain student in these online environments, that it does not go against that particular law and find them in violation of the FERPA Act, because that is really, really important. Okay, now those are all acts, again, laws, most of them, as you see, way before we had social media. But because of social media, we actually have some laws, some bills that are being proposed to be passed by laws that deal specifically with them. So, you know, this year in 2011, Senator John Kerry and John McCain actually introduced a bill called the Communications Privacy Bill of Rights Act. And it's very specific as to talking about, you know, companies that may collect, use, or transfer personal information through an online mechanism. Now, there are some qualifications, like it has to be information on more than 5,000 individuals in any 12-month period. But it does say you can only collect information that's reasonably necessary for what you're trying to accomplish, and there needs to be an opt-in if it deals with health information or religious affiliation. Okay, so that one has been proposed. It has not been passed, and there's another one called the Consumer Privacy Protection Act. That was commercial. This is the consumer one, and this was by Representatives Stearns and Matheson, and again, looking at not just the information that's collected before a sale, but also after a sale and how that information can be used. So this is an area that we're going to see that's going to be changing, right? It's going to be evolving, because although we have laws that are in place and can be applied today, there are also laws that are being drafted specifically to address what's happening with the social media and online networks. So again, this is an area as due diligence and as attorneys and legal professionals, we just need to be aware of and see where they're going so that we can best serve our clients. Okay, so what I'd like to do now is I want to change gears a little bit, right? From the privacy, I want us to look at some of the legal, ethical issues of using social media. And specifically, we're going to look at the ABA, or the American Bar Association rules. But I did want to bring up something recently. A law grad in severe financial distress made an offer on eBay asking for $200,000 for a law degree. And it's funny in a way, and it's also sad in another, but she goes on to say in the eBay account how, you know, it's been very little used and in prime condition, but she does give the disclaimer that if you purchase it, you still cannot practice law. But I just wanted to bring that up, and you have that in your handout if you want to find out more about what that ad is. Is it ethical to sell our law degree if we're not getting use out of it? We don't have a rule on that, but I just thought that would be a fun little thing to bring up because it is being done on eBay. Okay, so the American Bar Association has some model rules that really we need to be aware of as it relates to what we do as attorneys on social media. And I'm just going to bring some up so that we can discuss them together. The first one is to look at 1.6 and 8.3. The most important thing is about not disclosing confidential information. This is a breach of confidentiality, a breach of our attorney-client privilege. I mean, we have to be very, very careful about information that we put out there. You know, things like we might be excited that we won a case, but can we really tweet that we won this case if we settled something? Can we really tweet, oh, I settled this case and it was for this amount of money? You know, so many times when we settle a case in that settlement agreement, it will state, you know, that we cannot talk about. Very, very careful about what we tweet and post so that we are not going against that rule. 1.2, 1.4, 1.16, and 4.4 all caution against setting up unintentionally creating an attorney-client privilege, an attorney-client relationship. And I had spoken about this before, you know, talking about those disclaimers on websites that says that just because you get information here, it's just for educational purposes. It should not be construed as legal advice, but also it does not create an attorney-client relationship yet, okay? So they should not expect that things are going to be kept confidential. Any information that they put out there before that relationship is established is open and public, so they have to be careful about that, okay? 1.18 talks about dealing with prospective clients, and we have to be careful what we put there. And 7.3 talks about improper client solicitation. So as attorney, you know, we're supposed to be very careful about how we advertise our services so that we're not, you know, chasing the ambulances and all those stereotypes that they talk about, you know, how attorneys get their clients. And so those are things that I advise you to sort of read about and to sort of check against what you're doing online to make sure that you're not violating any of those rules. 3.5 and 3.6 really focus on the ex parte communications and dealing with trial publicity. You know, a lot of attorneys now are turning to social media to help garner buzz and support for their client's side of the story, but you have to be very careful about how you're using it, that you're not going against these rules when you do so. So again, it's a good thing to just take a look at that. 7.1 talks about no false or misleading information in advertising. You know, and I think I mentioned in one of the previous sessions this idea that, you know, you cannot have false information on your profiles or on your website. If you say you have experience in one area, you must have experience in that area, because potential clients are going to rely on that you have that experience when they then engage you to do and take care of their matter or their legal issues. So you have to be very careful that you're giving the right information. You know, and that, for example, something as simple as saying, well, I'll take a case on contingency and you don't have to pay anything. That's not really true, right? Because the client is always held liable for court costs, okay, and court fees and things of that nature. So it's not that they're going to pay absolutely nothing. They may not pay the attorney a fee if they lose the case because it's on contingency, but they would still have to pay the court fee. So you want to be very careful that clients understand the information that you put out there. Okay. Now, some state bars have already issued certain opinions as it relates with social media. So Virginia State Bar, you know, has, and you can Google this, quick facts about legal ethics and social networking. And they talk about the diligence and competence that attorneys should have. For example, they say, diligence and competence require the attorney to understand if and how his clients are using social networking, advise clients as to their future use of social networking to their best advantage, and to use, listen to this, Virginia is requiring attorneys to use social networking sites as investigative tools. In other words, if when we do our investigation, if when we do our research, we do not also look at social media and the things that are out there on social media under the Virginia bar, we are not complying with what we're supposed to be doing for our clients. Very, very interesting, isn't that? Another thing that Virginia State says is that, you know, be careful when LinkedIn, and they specifically point to LinkedIn, when LinkedIn asks for those recommendations or you're giving recommendations on LinkedIn, you need to be very, very careful and make sure they comply with all the rules of professional conduct, okay? And that a disclaimer is required for listing a specialty on LinkedIn, and this is Rule 7.4D. Disclaimer required. So I had mentioned this before when we did the session on social media and profiles. I have right before the specialty section, they say as an attorney, I do not have specialties. These are my focus. But for Virginia, it's actually required. Now that's Virginia, New York has opinions, and Pennsylvania has opinions, and I've mentioned that before. But those model rules are something that every attorney needs to be aware of. But not only that, we also need to have our staff, our paralegals, our receptionists, anybody that works for us, interns, understand those rules as well, because as the attorney, we will be held liable for what they do on social media as it deals with our firm and our clients. So that's our session on privacy and ethics. Thank you, and I'll see you at our next one.